Oh, yes. A defendant who is charged by citation, complaint, or information, Healthy Families of Clallam County, with an offense involving harassment and not arrested shall appear in court or arraignment in person as soon as practical, but in no event later than 14 days after the next day on which the court is in session following the issuance of the citation or the filing of the complaint or information. Yes. At that appearance, the court shall determine the necessity of imposing a no contact or no harassment order. Yeah. Now, as soon as you have information of violating the restraint provisions of a protection order, mandatory reporters, yes, you have the legal obligation to inform law enforcement of child abuse, yes, exploitation of children, yes, child abduction, kidnapping, poo. Now, when they waited 20 days, they actually are mandatory reporters, yes. They violated the RCW of not informing law enforcement of the knowledge that they had where they thought that I had violated the restraint provisions. But I was found not guilty of violating it because I wasn't trying to contact her. Pooh! Now, law enforcement allowed for her to file a dissolution of marriage while you did have knowledge within, a citation, complaint, or information. Pooch. Now, there's this big issue in Jefferson County about trying me for the 2-count criminal complaint by complaint. Yes. But when did the prosecuting attorney's office have information about the allegation of cyber stalking and violating the restraint provisions of a permanent protection order issued under 26.50? Did you have information for 7 weeks? Because as I understand it, when you don't do exactly what the law says within the time allowed by law, pooch, when you didn't file the criminal complaint on June 17th, whatever day that was, yes, and didn't give me notice of arraignment within 14 days so I could be arraigned, so I could explain that I wasn't in Brennan, Washington, yes, you intentionally withheld from the court knowledge of the possibility of cyber stalking and violating a protection order issued under 26.50. Yes. Now, I had often wondered, well, why was it that police didn't question me or interview me, Officer Larson? The Miranda rights, pooh-wee. Now, I'm wanting to get to suing today every mandatory reporter, yes, and quite possibly their next of kin, ouch. And all of those that thought, well, we don't have to tell law enforcement what we think is going on so that they can question the accused. Now, if I had been arraigned on the 17th, I'd have made some sort of arrangements to get to court. Yes. And it says within 14 days. Ow, 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 ow. But in no event later than 14 days after the next day on which the court is in session following the issuance of the citation or filing of the complaint. You decided to hold the complaint until you actually signed it on the 6th of August? Yes. Then you decided not to give me notice of court hearings on the 21st of August? Pooch. You waited an additional 21 days to transport me across county lines? Ouch. When I should have had notice of arraignment since I'm homeless? Yes. Now, there's always this big question about the failure to appear. Did I fail to appear when the prosecuting attorney's office had knowledge of violating RCW 98.46.050? Because I didn't. They had an obligation to inform law enforcement or file the complaint that next judicial day that the court was open? Yes. But they took it upon their own discretion to decide not to do that? Yes. Now, I would say that any individual in any school district, any mandatory reporter, coach, that had knowledge of this incident that happened in Brennan, I, as a father, have informed you that it's against the law to do what you're doing. I had thought about this maniac that could be out there posing as myself, considering you served somebody other than myself on August 28th of 2015. And let's find out. When did the prosecuting attorney receive information? Oh, crisis responder Carol Kirk. You should have issued a notice of arraignment within 14 days as soon as you had. Ouch! Now, the state of Washington Welfare Department custodial interference. Who was it that decided that I didn't need to know anytime somebody was violating a protection order that was issued where I didn't get any notice of the actual court hearings? Yes, the petitioner didn't appear in court, as if it were not necessary to have one of the parties in court on the day of July 31st of 2015. And how was it that you didn't strike it? You didn't strike it. Because as I'm sitting here looking at this RCW and thinking about the various times that I've been arrested, yes, it seemed to me that you don't. Now I'm going to want my sons today. Any information about the offense of violating 26.50 protection order? Has to be arraigned the next judicial day, yes. And in all instances, yes, issuance, the court is in session, but in no event later than 14 days after the next day of the filing. I should have been arraigned approximately June 30th by that time, yes. But you decided to sit on it for 7 fucking weeks.